Good evening, viewers. I hope you have a fantastic weekend. And today we have our guest. He has qualified as a solicitor, but quite interestingly, he has a lot of qualifications. And when we will start discussion, you will know that what he has achieved, and we will also share his experience. Today we have our guest, Mr. Arshad Rajput. He's qualified solicitor, and he has also qualification of a barrister. And originally, he qualified as an advocate High Court in Pakistan. Welcome to my show.
Thank you very much for inviting me to Sheffield Live.
Thank you. Could you please share your experience with our viewers that in early days, I've noted that you have worked in Pakistan as an advocate. How you see your experience working here in England and also working advocate in Pakistan?
I did my articleships that you normally call apprenticeship in Pakistan in 1998, and then I was admitted as a lawyer over there after completion of that. Soon afterwards, I joined the judiciary as a judge in Pakistan. So, and I worked there as a judge for about 4 years. The job of a lawyer in Pakistan is quite hectic in the sense that he's an advocate, he is a solicitor, and he does so many things on his own. So he is also his office clerk, he's also his office boy, he's also a lawyer. He also appears before various courts at district level and sometimes at high court level. So it is quite different in that sense. Here you have a very specialized area. For example, if you're working as a solicitor, you are very much confined to your office. So basically that is the main difference. And again, here advocacy is more or less practiced by barristers here. That is also now, there is not much difference left now because we now have solicitors also practicing as advocates. So, but in Pakistan, the lawyers, they have to go through so many things. So they have to do so many things. They have to draft their petitions, they have to lodge their petitions, they have to receive their clients, and they have to appear before the judges. So in that sense, it is different.
And in terms of your qualification, so you did your RLE education in Pakistan?
I received my all early education in Pakistan. I also did my law degree from Pakistan initially, from Punjab University Law College, Lahore. And when I came over to the UK, I re-qualified as a solicitor.
And in which year you did your solicitorship exams and then you did barristership exams?
I actually completed my conversion as a solicitor in 2003 and practiced about 5 years as a solicitor, and during that period I also qualified as a barrister. It was in July 2008 from one of the most prestigious inns, which is particularly of interest to subcontinent lawyers because Qaid-e-Azam also did. It was Lincoln's Inn. I did bar at law from there in July 2008.
Congratulations.
Thank
Viewers,
you.
now we will proceed towards our questions which we have put together for our guest. First of all, the question about the immigration law. If somebody has traveled in the United Kingdom on spouse visa and she has 2 kids, and in the middle of marriage, their marriage doesn't work and it breaks down, and if it is not working, is there any possibility that spouse, the wife, can stay in this country on the basis of the children?
Now, it depends that whether she came to the UK on the basis of immigration rules that were in force prior to 9th of July 2012 or immigration rules that were applicable after 9th of July 2012. Prior to 9th July 2012, there was a probationary period of only 2 years, and then one can apply for settlement after completion of 2 years if the marriage is genuine and it is subsisting. Now, after the change in rules, immigration rules in 2012. Now the settlement route and the probationary period is 5 years. So it depends if the children were born in this country or if the children are British citizens, then one can look at their circumstances and accordingly decide that in which category she can apply for further leave to remain in the UK. There is a possibility, for example, if the marriage is not subsisting, there is no way then she can apply on the basis of marriage, because there is no subsistence of marriage anyway.
Relationship's not there.
Yeah, relationship. But if she is the primary carer of her children, and father has literally abandoned the children, and if the father is no longer supporting her, if he has left the country for any reason, then there is a derivative right she can apply under European regulations.
I see.
Yeah, and on that basis, there is she should be granted further leave to remain for further stay. That is called derivative residence card she will be issued with. If she can apply, if she can provide proof of relationship, she can with the children, she can provide evidence that she is the main or principal carer of those children. Then on that basis, because the children are British, on that basis, she will be issued with.
So on the basis of children, she can apply.
Yes.
Thank you very much. And what's about, because in this scenario we have noted that the mother has been left with the kids, and of course they need to live somewhere, they need some help. So can they apply for some benefits?
Benefits is not exactly my area of law primarily, but the children are British anyway, and if they are in exceptional circumstances, she can always contact social services, and there are always certain circumstances. If someone is in real hardship, definitely she will be, because children can't be left on the road anyway. They have to be looked after, and it is the duty of the Home Office anyway that the welfare of children should be looked after and monitored.
Thank you very much. What are the main categories through which people can get indefinite leave to remain in immigration rules? If we can quickly, we can summarize this.
Since the introduction of these points-based system, they have more or less consolidated most of the routes. So there are only a few routes left which lead you to settlement. For example, if someone has come to the UK on the basis of marriage, then that route leads to settlement. One can acquire settlement after 5 years. If someone has come through work or business-related route, for example, if someone is on an entrepreneur visa or someone is on
investment
visa, then again, in an entrepreneur visa, they can qualify for settlement after 5 years. If someone is on as a sponsored worker, for example, on a work permit, it used to call work permit, now it is Tier 2.
Tier 2.
So if they're on that route, they will again qualify after 5 years. More or less every category, if you look at that, it leads to settlement after 5 years these days. But there are expedited routes. For example, if someone is investing a huge amount of money, so he comes in an investor category, then the process can be expedited. So that also leads to settlement. And also, for example, there are long residence category. If someone has legally spent 10 years in the UK, then he can apply for settlement after 10 years. And if someone has a mix, for example, some part of his stay is legal, some is illegal, then they can qualify after. They used to qualify after 14 years, but now they have to wait for about 20 years.
20 years.
Yeah.
Thank you. I have another question about linked with if somebody is coming for entrepreneur visa or investment visa and age is 65, still that person needs to qualify for the linguistics, for the English language requirements, or?
No, the language requirement is applicable up until the age of 65. After that, there is no requirement that you have to, because then that person comes within the purview of exemption. So that
even for the entrepreneur visa.
Yes.
So he can apply for the exemption.
Yes, he can apply for exemption. Yeah.
Thank you very much, viewers. I hope you are enjoying our discussion. And if you have any questions, you can always email me. My email is shown on your screens, and we will try to answer your questions in coming shows. Arshad, now I have another question for you. That is there any changes are coming in the rules, especially for the people who have overstayed in this country or who are living in this country for a long time? Is there any news in immigration changing in the law or and rules?
There is people usually spread various rumors around, but I'm not aware of any such
changes in the law,
amnesty or anything coming out which should be beneficial to these people. There used to be previously, which was known as a legacy scheme, which the previous government introduced, but that was also not an amnesty. Anyone who applied for asylum before March 2007, they were falling under that scheme. But the Home Office is now really very, very stiff and stern when it comes to overstaying, when it comes to breaches of immigration. So literally it is very, very difficult these days, and I don't see anything in the pipeline.
I see. Thank you very much. Another question about the similar style question, but a little bit variation in it. If somebody has a child who has stayed here in this country for 7 years, so is there any chance for the parents that on the basis of that child they can apply for their stay in this country?
You know, there used to be a concession previously that was known as Mike O'Brien's concession that was announced in 1998. So that stayed until recently, and that on the basis of that concession, he made a statement in the parliament, and that is part of Hansard now, that any child who has spent 7 years in this country, he has made this country as his main home. So there is no point uprooting that child and sending him back to country of origin, because he's not aware of that country, because Britain was his country.
Okay.
So that particular concession recently became part of the rules. Now that is part of immigration rules now.
I see.
And that is Immigration Rules 276 ADE, which is private life basically. Any child who is part of a family, and that child, if he has spent 7 years continuously in this country, then that family can apply on the basis of that child, that the child has lived in this country for 7 years.
So they have established their life in this country?
Yes, they have established their life in this country, and on that basis, because that concession is now part of the rules, and also that was primarily human rights issue also. So that is why that is now, that forms the basis of that immigration regulation, where 276 ADE basically, which covers this. So if they have spent 7 years, the children have spent 7 years in this country, yes, the family can apply for a, but the thing is, there is a difficulty. They won't be granted straight away indefinite. They will be granted 30 months.
30 months.
30 months leave, and after that they have to extend it, and on completion of 10 years, that they will be able to qualify for settlement.
Thank you very much. Quite a detailed answer. I hope our viewers have got the answer. Next question is quite interesting, because recently some people are applying for nationality, British nationality or indefinite leave to remain, and their application was rejected on the basis that when these certificates were checked on the basis of some college reasons or some due to some other reasons, they're not accepting these certificates. So what are the solutions for the people whose application has been rejected, so they can repass the set, or they can resit in the exam and then they can apply, or what are the solutions for their issues?
You see, it depends upon their individual circumstances primarily, how they obtained their certificate. If they are confident that they genuinely sat that exam and they were not part of any deception, or they were not part of any wrongdoing, and if they are still relying on their certificate, and if for any reason their application is their certificate is not accepted, for example, in case of an application for settlement or indefinite, they can challenge that decision by way of judicial review. One is that. Otherwise, if they don't want to go on that route, they can resit the exam and ask the Home Office to give them an opportunity.
If it is the fault of an institution or a college or a particular institution, so can the applicant be penalized for this?
Now the difficulty is, most of the people, whoever use such centers, they should be aware whether are they part of, if their certificate is genuine or not. But the Home Office is very, very stern in such cases. They believe that the people have exercised deception. They are part of that deception. So that is why they are penalizing those people. But it is always important to seek legal advice. If they believe that they have their
genuinely done the exam,
they have genuinely done the exam. Because what the institution was doing inside, behind the doors, so for example, if someone steps into a college and sits an exam, follows the procedure, and at the end of the day, after a couple of weeks, he's handed a certificate, he will believe that the certificate is genuine. And later on, if it is transpired that the certificate is not genuine, then that person has every reason to seek legal advice. And if they believe that the Home Office is not right in their decision, they can challenge that decision.
There's always wise saying, always seek independent legal advice. And if you have any kind of circumstances, you must seek independent legal advice. Now we proceed towards your about private life question. So do you have any interest in sports?
Yes, I do have a lot of interest in sport, and I very vehemently follow cricket.
And who is your favorite player?
Favorite player, there are quite a few, just not one. These days, my favorite team is primarily, I support Pakistan anyway, because I have attachment to that team as a result of my origins also, and also I have been playing cricket myself from the beginning when I was in Pakistan. So there are a couple of players now on the international arena. One of them was Shahid Khan Afridi. He is still playing the world. He is one of my favorite cricketers, and also nowadays I very much like Muhammad Irfan, because he's very, very tall guy, and when he throws the ball, it looks like as if the ball is dropped from a pole.
I see, quite interesting. I have a rapid fire question. Which is your favorite food? What food do you like?
I like potato in any shape or form, mixed with anything.
And your favorite place to visit?
It's mostly I like visiting Pakistan. So there is whenever there is a chance, I try to visit Pakistan.
How you feel and how you see profession in two countries, because you have practiced in two countries. You have seen Pakistan quickly, if you want to summarize, because of sometimes we have strict time restraints. So how you feel the difference in two judicial system?
You know, we claim that our judicial system is based on British legal system, but the British legal system has gone miles ahead of us, and we are still there. We are lacking in so many things, and the judicial system in Pakistan is still in very, very primitive phase. Because for example, if you look at the court procedures, and also there is not much legislation that is being introduced over there. We are still following civil procedure code and criminal procedure code. There are not so many changes in that. And also the court procedure that is used over there, that is not developing. It looks as if it is still stands still. It is not moving. But here in this country, if you look at the substantive side of law, every minute there is some
continuous progression.
There is continuous progression, in the sense that there is always some sort of law being made and passed. And also the court procedures and technology and things, they are very, very quickly adopted and utilized in day to day.
Any message for our viewers from your side? Because we are coming to conclude our show.
My message to our viewers is, whenever you are entangled in any legal problem, it is important that you must seek proper and independent legal advice, and never try to compromise on seeking proper legal advice, because if you try to do so, you may have to face consequences of that, and which couldn't be very beneficial for you in the long run.
A very beautiful summary from Arshad, that whenever you have any problem, always seek independent advice. And this is the objective that when you have any situation, you go to your lawyer, go to your advisors, seek independent advice. And I think this is the best conclusion we have from our guest. And thank you very much, Arshad, for joining me today.
Thank you.
In coming days, we will share more news, more updates on the law. And this was episode of Guest with Nazir. Keep watching Sheffield Live. Thank you.